Welcome, everybody. We are pleased that you have joined us for today's webinar titled The 10 Most Common Life Insurance Mistakes, Real Court Cases and Lessons. The webinar will last approximately 15 minutes, and at the end, you will be given an opportunity to receive supporting materials by email, free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning law practice. Linus now writes extensively for life insurance industry publications, and he speaks regularly at industry events. His new book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, written together with a CPA and a business broker, will be available now on Amazon.com. Linus will draw on his legal, life insurance, and practical experience for today's webinar, and here he is.
Thank you, Lisa. I appreciate that very much. Today's content is from the April issue of Think About It. For more information about subscribing to Think About It or one of our other monthly newsletters, feel welcome to visit advancedunderwriting.com, advancedunderwriting.com. So I'm going to talk briefly today about the 10 most common life insurance mistakes with some real court cases and lessons that kind of highlight some of the things that either emphasize the points I'm going to make or perhaps show some ancillary issues. The most common mistakes generally have two things in common. First of all, they have potentially serious consequences, but secondly, the mistakes can be fixed or avoided if they are found in time. When the mistakes are not avoided, the group that the insured cares about most, usually close family, but can also be business or other folks that are close to them, are the ones that suffer the most. And agents can certainly be exposed if the client feels the need to sue, or if the family feels the need to sue as a result of the mistakes. So it's really an opportunity for you, if you're working with clients, to help them plan properly and review their circumstances so that these mistakes can be discovered and avoided completely. So let's go ahead and get started. With the idea that mistake number one is that the insured's estate is the beneficiary. This can happen with life insurance, but can also happen with other types of assets for which beneficiary designations can be made, annuities or IRAs or other beneficiary assets. Why is naming the estate the beneficiary a mistake? Well, first of all, it delays the heir's access to funds because the funds must go through the probate process. One of the beauties of having a named beneficiary of life insurance or another asset is that the named beneficiary is able to access the asset without having to go through probate. And so the probate process is avoided if there is a named beneficiary. If the estate is the beneficiary, that process is not avoided. What are the downsides of having to go through probate? First of all, privacy is lost because assets subject to probate become part of the public record. The second problem is funds can be subject to the claims of the decedent's creditors. That's part of the reason for probate, is that anybody the decedent owed money to while alive have a chance to collect it out of the probate assets after the decedent's death. If you've got a named beneficiary of a life insurance policy, those creditors don't have easy access to the money. And then finally, if the decedent has no valid will at death, the states provide one. The intestate rules may not match up with what the decedent would have wanted if there had been a named beneficiary. So for all of those reasons, having the estate as the beneficiary is a problem. There's one more reason, illustrated by a recent bankruptcy court case. In late 2014, a woman by the name of Nicole Byrne filed for bankruptcy. In 2015, after her bankruptcy filing, her husband passed away. He was not part of the bankruptcy filing. He had a slightly over $100,000 term policy that was payable not to Nicole but to his estate. Nicole asked the bankruptcy court to protect the life insurance proceeds from her bankruptcy proceeding. And the court decided that if Nicole had been the beneficiary directly, the proceeds would have been protected, but because the estate was the beneficiary, the proceeds were not exempt and were thus available to satisfy Nicole's creditors. So in this particular case, if Nicole had been the beneficiary directly, she would have kept the life insurance proceeds. Because the estate was the beneficiary, she was not able to keep the life insurance proceeds. So what's mistake number 2? No named contingent beneficiaries. This is a corollary to mistake number 1. If there is no contingent beneficiary, that means that the estate ends up being the default beneficiary with most carriers if the primary beneficiary has not survived the insured. And so you've got all the problems where there's no contingent beneficiary, all the potential problems that you have with naming the estate beneficiary. And so it's always a good idea to review a client's beneficiary designations on a regular basis to make sure that the primary and the contingent beneficiary designations are both valid. Mistake number 3, minors or other impaired persons are named beneficiary. This happens most often with minors, and I get a lot of calls from folks who want to know how best a minor might be named beneficiary of someone's life insurance policy or contingent beneficiary. And the best answer is that a trust is usually the right way to do it. The client's able to impose a lot of structure to how the minors will access funds, have a lot of flexibility on when those funds are ultimately released when the minor comes of age. And so the trust is usually the right choice. Most of our clients won't go to a lawyer to have a trust drafted, even if it's inside of a will. And so for those circumstances where a minor beneficiary is needed or needs to be dealt with, you can use the UTMA rules to provide, some kind of trust-like structure to funds for the benefit of the minors, so that a more complicated process isn't followed. If you name a minor directly and the minor ends up being in line for money while the minor is still a minor, somebody's got to go to court and petition the court to be appointed to manage the funds for the minor's benefit. That process is hard and expensive, and it requires a lot of supervision over the person who's named the guardian or the conservator. And so that's the downside of that. In addition to minors ending up being in line for life insurance proceeds, sometimes people who are impaired end up being in line, and if they're named the beneficiary, you can have the same potential for needing a conservator, or if they're collecting needs-based government benefits, it might screw up their benefits. So, all of those issues need to be explored with the client, and the idea that minors or other impaired persons might be in line for assets need to be dealt with either through UTMA or more robustly with a trust as beneficiary. Now, I understand in a lot of cases people don't want to go to a lawyer and have a trust done up. What happens if somebody tries to do a shortcut? Well, let's talk a little bit about the case of Castellotti versus Free. In the Castellotti case, a mother with two adult children decided to leave all her assets to her daughter in order to shield the assets from her son's soon-to-be ex-wife. The children, on their own, agreed that if the son paid the estate taxes due with regard to mom's estate, the daughter would split all the assets with her brother. After her mother's death, the son, in fact, paid mom's estate taxes, but the daughter refused to split the assets with him, and so he ended up having to sue. And mom could have avoided this outcome, avoided, having the kids have to trust each other and one kid ultimately failing in that trust by naming a trust as beneficiary rather than just trusting her daughter to do the right thing. So shortcutting the process, the right process, can lead to litigation in the family, lead to a loss of assets because the kids end up fighting, and that ends up being expensive. Mistake number 4, the beneficiary language is wrong or unclear. That happens a fair amount, and here's a great example, this case of Metropolitan Life Insurance Company versus Dice. The facts really kind of say it all. The insured listed her beneficiaries on her life policy as follows. Denise, half the policy, and each of the grandkids, 4/5 of the policy, and then mom another 1/5 of the policy. Well, if you add up all of those fractions, you realize that the insured tried to list beneficiaries for 150% of the policy's death benefit. How would you like to have been the attorney who helped create that beneficiary designation? Now, in this case, apparently the agent wasn't involved, and so the client did this on her own and made the mistake and left it to the family and ultimately the court to sort out what she really had in mind. Good luck with that. It's expensive to try to figure out what she had in mind, and the court case resulted. And so family was unhappy. And so if you're an agent, it's in your interest to help your clients and your prospects review their beneficiary designations to make sure they haven't fallen into this particular trap. Mistake number 5, family needs not adequately addressed. We sell life insurance for a lot of different reasons. One reason is family needs. The family wants there to be enough death benefit to make sure that the surviving family members are taken care of in the way that they expect to be taken care of. So family needs not being addressed is certainly an issue. Expectations and the failure of expectations can manifest themselves in a lot of different ways. Here's one example. This case, C&C Family Trust versus AXA, involved a situation where a trust was the owner beneficiary of a life insurance policy purchased from AXA. When the policy was delivered to the trustee asked the agent about the differences between guaranteed and projected policy performance. And the trustee believed that the policy was guaranteed to stay in force if the scheduled premiums were paid. In 2012, AXA informed the policy owner that additional premiums would be required to keep the policy in force. That never happens, right? Where a client misunderstands how a flexible premium policy is going to perform, believes the policy's values and death benefit are guaranteed, and it turns out that more premium is needed to keep the policy in force. In this case, the trustee sued over the unmet expectations. Regardless of the outcome, that's expensive. It involves the agent losing time, losing perhaps reputation over the procedure, and you know, the question is, how can that be avoided? Well, a couple of things. First of all, make sure you're as clear as you can be on the front end with regard to how the policy performs, and secondly, keep in contact with the policy owner on an annual basis to make sure that expectations are adjusted over time based on actual performance of the policy. Constant communication over these types of issues can help manage the expectations. If the trustee doesn't hear, or the policy owner doesn't hear from the agent for years and years, the memory about what was said at the beginning may turn out to be faulty. So mistake number 6, the wrong ownership is chosen for the particular case involved. This particular case has to do with a buy-sell agreement. Amy Bozick owned a successful business, Flying Nurses International, and she had a key employee. In 2011, they entered into an agreement that would have allowed Batchelor, the key employee, a right of first refusal to purchase the company should something happen to the 100% owner, Bozick. Batchelor owned and was the beneficiary of a policy on Bozick's life in order to fund the buy-sell agreement, the buy-sell arrangement. But it was an optional buy-sell arrangement. In 2014, Bozick died. Batchelor collected the life insurance proceeds and declined to purchase the business. Bozick's estate sued, which is why we know about this case. It's a real case. As far as I know, it hasn't been completely worked out yet. And this is a situation where the expectations were unmet. Bozick permitted insurance to be purchased on her life, allowed Batchelor to control the policy and control the beneficiary designation, but didn't obligate him to buy out the business interest in the event of her death. She did die, and the worst of both worlds happened. Batchelor received, the key employee received the death proceeds, decided to keep them, and decided not to buy the company. And so obviously litigation resulted. This thing could have been structured better on the front end, either with a mandatory buyout or by Bozick keeping control of the life insurance policy. So mistake number 7, ownership creates a tax problem, either income tax or gift tax. This comes about where you've got a third-party owner of a life insurance policy naming a different third party as the beneficiary of the life insurance policy. We sometimes call this the Goodman Triangle. I've heard it referred to as the unholy trinity. In any event, it's a situation to be avoided. In a business situation, third-party ownership with different third-party beneficiary creates an income tax problem. In a family situation, third-party ownership with a different third-party beneficiary creates a gift tax problem at death. Either one of them is a potential disaster, particularly if you're the agent who is involved in the purchase of the policy. Mistake number 8, Section 101J requirements have been neglected. 10 years ago, Congress and the President decided that it was a good idea to tax the death benefit of business-owned life insurance unless notice and consent requirements were met prior to policy issue. It surprises me how many agents still don't quite understand that this is a requirement for business-owned life insurance, that you get notice and consent signed prior to policy issue. If you don't get it signed prior to policy issue, the income tax taint on the policy appears to be permanent. There was a private letter ruling in 2012 where a formal notice and consent was not obtained prior to policy issue, but because there was a buy-sell agreement in place and it referenced the policy that was needed to fund it, the IRS ruled that that was adequate. In those circumstances, the actual technical requirements of Section 101J were met. I wouldn't take too much comfort out of that private letter ruling. I would be very paranoid about Section 101J, and I would definitely make sure that the notice and consent form was secured as a separate form prior to policy issue on those policies issued since 2006. Mistake number 9, buy-sell arrangement has not been properly reviewed. We talked a little bit about the Broderdorf case earlier. This is another case that was decided in the last 10 years, the Sassover case, where the buy-sell agreement didn't really set a fixed price for the buyout in the event something happened to one of the doctors. And because of that ambiguity, the buyout didn't work the way that the doctors had intended, and litigation resulted. So if you're working with people on buy-sell planning, make sure that not only the life insurance is set up properly, but that the buy-sell agreement will actually work the way that they intend. We can help you with that if you're not sure whether it's going to work right or not. And then mistake number 10 is that the life insurance policies have not been reviewed and the beneficiary designations have not been reviewed after a divorce or other life event. We see a lot of cases where beneficiary is screwed up after a divorce. The two cases here, Potential Life versus Cushman and Volk versus Gosser, both involve litigation after a couple divorced, and a question of who the money should be paid to in the event of a divorce where perhaps the ex-wife was left as the beneficiary, or the terms of the property settlement or child support agreement were not honored, where there were requirements to change beneficiaries a certain way and that wasn't done. And so the courts got involved, and that ended up being expensive for everyone involved. And so those types of circumstances ought to be managed on the front end. So let me wrap this up. First of all, by saying, these mistakes come up a lot. I've seen them in my career as an estate planning attorney, in addition to them coming up from the questions that life insurance professionals raise to us at our firm. In most cases, these circumstances can be avoided or fixed, but you got to know about the circumstances to be able to help your clients avoid or fix the problems. So policies should be reviewed often. You should stay up to date with your clients and the events going on in their lives, and help them to be vigilant and purposeful in trying to avoid these pitfalls. Those lead to better outcomes for you, for your client, and for your business. We hope you find this information helpful in your practice. If we can help you, please let us know. Thanks for listening. And now, Lisa, please wrap us up.
Will do. Thank you, Linus. Thank you all for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact me, Lisa, at 615-224-1291. Thanks again, and best wishes for continued success.